Okay. Henry Griffith. Who's the plaintiff in this case? Who filed the suit? What's her name? Okay. Freya Paul Griffith. And what is he? I mean, what is she? And what happened to her? Citizen of another country, not the United States. And why? I know, but why? Why does that matter? Yes, Rule 8, 1 of the Connecticut Practice Book. So the question is whether this violates Equal Protection Clause of the Constitution. So we first have to, whenever there is a constitutional a question of equality, you first have to, think of that balance between public interest and private interest. So to talk about the public interest, you have to understand why the law was passed. Why do we have such a rule? Why does the Connecticut have such a rule? Or why do you think that there is such a rule?
I guess it is to protect the American citizens from too much aliens coming.
Okay. So you can kind of imagine, why such law was passed or such a rule was made. If you look at the dissent, page 155 through 157, there is, some understanding of why the rule was passed. So, can you point to a paragraph? Let's look at paragraph 36 and paragraph 37. The state traditionally have had great latitude in prescribing rules and regulations concerning technical competence and character fitness, governing those who seek to be admitted to practice law. The importance of lawyers and the judiciary in our system of government and justice needs no extended comment. An attorney is an officer of the court. In Connecticut, a status this court has also recognized. He represents his client, but also in Connecticut may sign writ subpoenas, take recognizances, and administer oath. 그래서 sign writs and subpoenas는 이제 법원에 어떤 내는 신청서 또는 이제 증인한테 보내는 소환장. 소환장이 이제 서핀하고 writ은 그 writing을 줄여서 writ이라고 해요. 옛날 말로. take recognizance 이건 이제 그 변호인으로서 그 자기 그 피고인을 이제 책임지겠다라고 할 때 이제 take recognizance 한다고 하고 sign administer oath는 administer 이거는 뭐냐면 oath는 이제 선언이죠. 선언. 그러니까 일종의 공증을 받을 수 있는 그런 그 권리, 그러니까 권한을 가지게 된다. 이런 공적인 역할을 수행한다는 거죠. And more important than these emoluments of their position is the tremendous responsibility and trust that our society places in the hands of lawyers. The liberty and property of the client may depend upon the competence and fidelity of the representation afforded by the lawyer in any number of particular lawsuits. But by virtue of their office, lawyers are also given and have increasingly undertaken to exercise authority to seek to alter some of the social relationships and institutions of our society by use of the judicial process. No doubt an alien, even under today's decision, may be required to be learned in the law, familiar with the language spoken in the courts of the particular state involved, but the Connecticut's requirements of citizenship reflects its judgment that something more than technical skills are needed to be a lawyer under our system. I do believe it's not. I do not believe it is irrational for a state to make. I do not believe it is irrational for a state that makes that judgment to require that lawyers have an understanding of the American political and social experience, whether gained from growing up in this country, as in the case of a native-born citizen, or from the naturalization process, as in the case of foreign-born citizen. Okay. So that is the supposed reason for limiting lawyering only to the citizens. What do you think? Do you think that that is a compelling enough interest? And do you think that barring aliens, barring non-citizens completely from lawyering is necessary for accomplishing that interest? What do you think? That's the question you should ask, right? What does the court say? First of all, what level of scrutiny does the court apply to this case? Okay, how do you know that? Well, does it say strict scrutiny or something similar?
Paragraph 10 and 11.
10 and 11. Yes. Also, paragraph 9, it ends with a sentence, for whom such a heightened judicial solicitude is appropriate. And why? Why is that? Why do you think that this discrimination based on citizenship is subject to heightened scrutiny or subject to strict scrutiny? Why is there suspicion that anything turning on citizenship maybe, okay, why is there a suspicion that anything turning on citizenship may be artificial and intentional discrimination? If you look at paragraph 9, it says, classifications based on alienage, like those based on nationality or race, are inherently suspect and subject to close judicial scrutiny. Why? Because aliens as a class are a prime example of a discrete and insular minority. discrete and insular minority. discrete는 이제 쉽게 구별되는 그런 의미고요. insular는 섬처럼 이렇게 포위된 소수이면서 이렇게 포위된 그런 이제 소수다. 그렇기 때문에 힘이 약하기 때문에 뭔가 법이 통과됐다면 이 사람들의 그 의견이 반영되지 않은 상태에서 이 사람들에게 불리하게 통과됐을 가능성이 높다라고 보는 거예요. 그래서 discrete and insular minority란 말이 그 프레이즈 이것만 가지고는 그 뜻을 다 이제 알 수 없었겠지만 그런 의미에서 그런 걸 쓰는 거예요. Do you think that women are discrete and insular minority? Okay, depends on what?
I don't think in US it is not.
Okay, how about in Korea?
Korea, it is disputable, but like countries like India, they should be.
It's because they should be considered insular minority. Okay. What if India has a greater number of female legislators than Korea does? Okay, all right. So yeah, those things we have to look at to figure out whether something is suspect classification. But what's more important is the Supreme Court has not broadened the scope of suspect classification outside alienage, nationality, and race, and possibly wealth as well. So that's the level of scrutiny. And does the Connecticut state succeed in meeting that, satisfying the strict scrutiny? How about the compelling government interest? What does the court say about that? What's the interest? Okay, but why is excluding alienage related to finding or setting the standard of becoming a lawyer. If you look at paragraph 14, right? In order to establish a link between citizenship and the powers of responsibility of the lawyers in Connecticut, the committee contrasts a citizen's undivided allegiance to this country with the resident alien's possible conflict of loyalties. From this, the committee concludes that a resident alien lawyer might, in the exercise of his functions, ignore his responsibilities to the courts or even his clients in favor of the interest of a foreign power. Right? So that's the core interest that they are trying to achieve. And what does the court say about that? So, is it, does the court say, does the court say the interest is not important enough? Or does the court say the importance is interest enough? I mean, the interest is important enough, but the state action here, right, exclusion of all aliens, is not necessary for that interest. Which one does the court say? Okay, can you kind of point to the relevant language? Okay, where? Paragraph 15, okay. Certainly the committee has failed to show the relevance of citizenship to any likelihood that a lawyer will fail to protect faithfully the interest of his clients. Nor would the possibility that some resident aliens are unsuited to the practice of law be a justification for a wholesale ban. Right? So here, the court is not saying what the state tries to achieve is not important. It is important, but is it necessary to alienate aliens? Then what alternative does the court present? What alternative is there? Yep, paragraph 19. Connecticut has wide freedom to gauge on a case-by-case basis. 에일리언들을 다 외국인들을 다 배제하지 말고 케이스-바이-케이스로 판단을 합니다. And Connecticut can require appropriate training and familiarity with the Connecticut law. Apart from such tests of competence, it requires a new lawyer to take both an attorney's oath to perform its functions faithfully and honestly, and a commissioner's oath to support the Constitution of the United States and the Constitution of the State of California. And goes more. Moreover, once admitted to the bar, lawyers are subject to continuing scrutiny by the organized bar and the courts. In sum, the committee simply has not established that it must exclude all aliens from the practice of law in order to vindicate its undoubted interest in high professional standard. So there are other ways of achieving the same interest, same governmental interest, which is apparently important. Why do you have to ban all aliens? Okay. Now, the court deals with another argument. So if you look at paragraph 20, its thrust is not that resident aliens lack the attributes necessary to maintain high standards in the legal profession, but rather that lawyers must be citizens almost as a matter of definition. Why? Only citizens must be lawyers as a matter of definition. Why? Right. So lawyers are officers of the court, and for someone to be an officer, if you want to be an officer, if you want to be an officer in the Republic of Korea, can a foreign citizen become an officer? So that's the argument. And what does this court say about that? They are not officers. Okay. What do you think about this? When you pass the bar, would you rather be an officer? Would you rather be called an officer of the court, or so officer of the court, responsible for public interest? Or would you say, I would rather be a lawyer, just a lawyer, not public officer, just faithful to my client? What would you do? Sorry. What would you do? Lawyer? How many want to be an officer? Yeah. So the court is saying that the term officer is only a metaphor, right? So if you look at paragraph 23, in case of Ex parte Garland, okay, it's an old case. In Ex parte Garland, the court pointed out there that an attorney was not an officer within the ordinary meaning of that term. Certainly nothing that was said in Ex parte Garland or in any other case decided by this court places attorneys in the same category as marshals, bailiffs. 마샬스는 이제 뭐 경찰의 일종인데 이제 사법 경찰, 그러니까 사법부에서 일하는 경찰들이죠. bailiffs 이건 저기 그 법원 내에서 그 석이라고 해야 되나? 석인 뒤에 나오네. court clerks, judges. Unlike these officers, a lawyer is engaged in a private profession, important though it be no our system of law. In general, he makes his own decisions following his own best judgment, collects their own fees, runs his own business. The word officer, as it always been applied to lawyers, conveys quite a different meaning from the word officer. Okay. What does the dissent say about this? The three choices. Does the dissent say, we have to apply lower scrutiny? Or does the dissent say, it passes the strict scrutiny? Right? Which one of the two? Does the dissent say exclusion of aliens from lawyering profession should be subject to strict scrutiny and passes, or should be subject to lower level of review? Lower level of review. Why? What?
Because in the 14th Amendment, it says all persons born or naturalized in the United States.
Yep.
Are the ones who are
Paragraph 29, right? Paragraph 29 toward the last 7 lines. The principal purpose of those who drafted and adopted the amendment, this is the 14th Amendment, was to prohibit the states from invidiously discriminating by reason of race. Because of this plainly manifested intent, classifications based on race have rightly been held suspect under the amendment. But there is no language used in the amendment, nor any historical evidence as to the intent of the framers which would suggest to the slightest degree that it was intended to render alienage as a suspect classification. So, what do you think about this? Alienage, aliens. So the majority is saying, okay, well, aliens are insular and discrete minority because it's discrete because it's easy to characterize. Whoever doesn't have a passport or citizenship are aliens, right? It's easy to define. That's what's meant by discrete. Insular means, kind of under siege imposed by majority. Yes, because, aliens, they cannot vote, right? Their voices are not reflected in the political process. So there is a high likelihood that if a law was passed to discriminate against or differentiate or classify them, that law is likely to be discriminatory to the aliens. That's one theory. The dissent is saying, no. We're not going to look at whether, it's good to apply strict scrutiny on alienage classification, we'll just look at what the framers intended. We'll just look at what the intent behind the 14th Amendment was. The intent behind the 14th Amendment was to fight against racial discrimination. So only race should be subject, only racial classification has to be subject to strict scrutiny. Which one of the interpretation do you think is better? Huh? Majority opinion. Okay. But is that a legal argument or are you making a political argument, right? I mean, the best way to interpret law is the legislative intent. Now, for the Constitution, you don't use the term legislator because, you don't legislate Constitution because the Constitution is a higher law than what the legislature makes. So this is a fight between, long fight between the conservative Supreme Court justices and the progressive justices. And conservative justices have advocated for what's called the original intent theory. Basically, 법을 해석하는 방법이 몇 가지가 있죠? 한번 분류해 보세요. 법을 해석하는 방법. 여러분들 배웠을 것 같은데 법률정보조사에서. 가장 쉬운 거는 문헌적인 해석. 그 다음 쉬운 게 체계적 좀 어려워 보이지 않아? 기분에? 역사적 좋아요. 역사적이라는 건 뭐의 역사? 법 제정의 역사에서 뭘 보는 거예요? 그렇지. 입법자의 의도, 입법 의도에 따른 해석. 그 다음은 체계적 해석. 그리고 또 이제 법의 객관적인 목적에 따른 해석. 법의 객관적인 목적이라는 것은 법이 만들어지면은 처음에 법을 만든 사람이 부여했던 역할과 달리 다른 역할을 수행할 수 있다는 거죠, 나중에. 그러면 또는 다른 역할을 부여해야 된다라는 일종의 좀 도덕적인 주장이 있을 수가 있죠. 또는 그게 도덕이 아니라 경제적인 이유로 그런 목적이 부여된다고 생각하는 사람들도 있고, 또는 사회 발전을 위해서 그런 목적이 부여된다고 생각하는 사람들도 있고. 그래서 전체적으로 보면은 이것도 이미 여러분들 제가 나눠드렸던 그 첫 번째 매뉴스크립트에 다 나온 건데, 문헌적 해석, literal interpretation, 입법자의 의도에 따른 해석, 이게 이제 legislative intent, 또 체계적 해석, systematic, 그리고 체계, 법의 객관적 목적. 그래서 그러니까 법이 도덕을 보호해야 된다라고 생각하는 일파들이 있죠. 네. 그래서 morality. 그래서 이 사람들이 보면은 칸트, 하버마스 이런 사람들에게 들어가는 거고, 법은 법한테 부여하는 객관적 목적 중에 하나가 바로 경제. 그래서 law and economics. 또 사회 변혁을 주장하는 사람들도 있죠. 사회 변혁을 목표로 하는 사람들을 리얼리스트라고 또 불러요. 사실은 이렇게 봐야지. 리얼리스트가 여기서 리얼리스트라고 하는 거는 처음에 법을 무슨 의도로 만들었는지 이런 거 볼 게 아니라 법의 사회적 실체를 보자는 거예요. 사회적 실체. 법이 지금 이 사회에서 어떤 역할을 하고 있는지. 네. 그래서 현실을 보자라고 해서 이제 법현실주의자들이라고 해요. 법현실주의자. 그래서 법현실주의자들 밑에 이제 이런 사람들이 있죠. 법경제학 하는 사람들도 있고, 또 critical theories라고 해가지고 법을 이제 사회적 변혁의 도구로 보는 사람들도 있고, 또 pragmatist라고 해가지고 실용주의도 있고 사람들이. 그래서 이게 하나의 리얼리스트고, 이 사람들은 어떤 법을 그래서 이 사람들은 좀 소수고 참 이름 붙이기가 어려운데, 그러니까 법을 사회적 맥락에서 보는 게 아니라 어떤 좀 초시대적인 그런 가치를 그래서 그 가치가 이제 모랄리티가 되는 거죠. 모랄리티. 그래서 모랄리티를 보호하기 위해서 법을 해석해야 된다라는 사람들이 있고, 주로 이제 입법자의 의도와 문헌적 해석을 하는 이분들이 이제 legal positivist. 그 사람들은 이제 법실증주의자라고 그래요. 그래서 법철학이 보면 이렇게 좀 이렇게 삼국지처럼 이렇게 세 계파가 계속 서로 논쟁을 벌이고 있고, 실제로 법원 판결들을 보면은 이 법실증주의하고 다른 법실증주의와 이쪽 법의 객관적 목적을 더 중요하게 생각하는 위파들 사이에 이제 논쟁이 계속 벌어지게 됩니다. 어느 게 더 올바르냐? 그건 한번 판단을 해보세요. 자, 그래서 이제 dissent는 뭐라 그래요? Strict scrutiny or low level review? Low level review, right? Because the framers, the one who made the Constitution, intended only to include race. Or, in the end, who do you think won? This case was decided when? (1973). So many years ago. In the end, who do you think have won? The positivist or moralist and realist? or at least on this issue, right? Whether they should recognize other suspect classifications that call for strict scrutiny or heightened scrutiny on that issue, which side has won? Moralist, realist, right? How do you know that? What?
Because we can take bars in America.
Ah, good point. Well, because yes, gender was later included, and gender was never the intent of the people who passed the constitutional provision. At least not literally, they never intended it. This was, these were the years that women could not vote, right? So, okay, having said that, so dissent wants to apply low-level review, and how does it do that? Paragraph 35, right? Paragraph 34, in my view, the proper judicial inquiry is whether any rational justification exists for prohibiting aliens from employment in the competent civil service and from admission to a state bar. Remember, any rational justification, right, doesn't require a reasonable justification, but any rational. 미치지 않은 이렇게 읽으면 돼요. 뭐 이성적인 이렇게 뭐 읽어도 되고 합리적인은 아니야. 이성적인 사람과 합리적인 사람 누가 더 좋아요? 합리적인 사람이 좋다고 그냥 생각하세요. 예, 예. 사람들이 뭐 다 그 단어를 다르게 쓰기 때문에 뭐 내가 강요를 할 수는 없지만 하여간 이 수업에서는 reasonable reasonable requires some substantive rectitude, while rationality requires just tendency to be consistent. You can be consistently selfish. Okay, that's rational, right? So another way of explaining this standard is in paragraph 35. Fifth line, a statutory discrimination will not be set aside if state of facts reasonably may be conceived to justify it. Conceived. Conceived라는 거는 conception, 잉태한다는 얘기죠. 즉 뭐냐면은 그냥 개념적으로 이 법으로 저런 목적을 달성할 수 있겠구나 라고만 판단되면 합헌이라고 보는 거죠. 그래서 그 뒤에 보면 이 low level review하고 strict scrutiny하고 큰 차이가 나는 게 strict scrutiny에서 뭐라 그랬어요? 변호사들의 실력을 이게 정확히 검증하는 건 중요하지만 그건 개별적으로 시험을 보면 되는 거 아니냐? 왜 외국인들은 다 그냥 배제를 하냐라고 했잖아요. 네. 그래서 그 실력 검증에 반드시 필요한 게 아니다. 네. 그러니까 외국인이면 뭐 커네리컷 법도 잘 모르고 미국 정치 역사도 잘 모를 수 있지만 여튼 개별적으로 판단해야 될 일이지 배제해서는 안 된다. 디센트에서 뭐라고 하냐면은 157쪽 그 긴 문단 밑에 거기 딱 중간쯤에 I suppose부터요. suppose부터 보세요. I suppose the Connecticut Bar Examining Committee could itself administer tests in American history, government, and sociology, but the state did not choose to go this route. Instead, it chose to operate on the assumption that citizens as a class might reasonably thought to have a significantly greater degree of understanding of our experience than would aliens. Okay. So the dissent recognized that there is a less infringing way of realizing that same interest. But because this is a low-level review, because this is rational-based review, as long as it is rational to think that excluding all aliens will be, will help getting good lawyers, then it's okay. Okay? The state can make choice. The state can choose to take the more infringing option. 그러니까 침해 최소성을 요구를 안 하는 거죠, 여기서. 그래서 이것만 보면은 또 한국 헌법은 항상 침해 최소성 계속 요구를 하니까 더 국가에 대해서 엄격한 게 아닌가 뭐 그런 판단도 그런 비교도 해볼 수가 있죠. Okay, let's go to Amback versus Norwich on page 159. All right. Now it's elementary and secondary school teachers. Okay, and law forbids. Paragraph 3 forbids certification as a public school teacher of any person who is not a citizen of the United States unless the person has manifested an intention to apply for citizenship. And the question is whether this law is unconstitutional. So he was a lawyer in Griffith. Now in this case it's elementary teachers. Okay, before you read the case, what do you think should happen? Elementary and secondary public school teachers. Should they be all citizens? What do you think? What can be the reason for excluding aliens?
School teachers have to teach history and English. So,
Well, aliens can teach just as better if they study.
Since it's like elementary school and secondary school is mandatory in the US, mandatory education,
Mandatory. Even high school is mandatory.
then if they would be regarded as officers.
Okay, right, good argument. So maybe they are carrying out the official functions of the state. Okay. But like cleaning streets, that's an official function. Does it have to be done by citizens? Because it's an official function? Okay, think about it. Let's look at what happened in the lower court. So paragraph 5, three-judge district court was convened, applying the close judicial scrutiny, so strict scrutiny. The law was struck down. The court believed that the statute was overbroad. excessive하다는 거죠. 과잉금지 원칙에서 말하는 그 과잉. overbroad because it excluded all resident aliens from all teaching jobs regardless of the subject taught. The alien's nationality, the alien's relationship to this country, so what do you think should happen here? The first, decide what level of scrutiny applies, right? Okay? Because that changes the result greatly, right? So what level of scrutiny does the court end up applying in this case? Really? Okay. All right. Can you explain where and how? Strict scrutiny is applied? I'll save time for you. Paragraph 9, the court says, exclusion of aliens from such governmental positions would not invite as demanding scrutiny from this court. Okay. Applying the rational basis standard, we held last time that New York could exclude aliens from the ranks of its police force. Foley case. Because the police function fulfilled the most fundamental obligation of government to its constituency and by necessity cloaked policemen with substantial discretionary powers, we view the police force as being one of those appropriately defined class of positions for which a citizenship requirement could be imposed. Paragraph 11, the rule for governmental functions, which is an exception to the general standard applicable to classifications based on alienage, rests on important principles inherent in the Constitution. The distinction between citizens and aliens is fundamental to the definition and government of a state. Okay? And then the court goes into discussion of whether teaching in public school is a governmental function like the police. Okay. And what does the court decide? The court decides that public school teachers are part of a government function. Okay. So what standard should be applicable since this is a governmental position? Rational based review or strict scrutiny? Rational based review. So look at paragraph 16. Third line, it remains only to consider whether section 3001, paragraph 3 bears a rational relationship to this interest. And the court decides, it is rational. Okay, it is constitutional. What does the dissent say? Does the dissent say should heighten the scrutiny, heighten the level of scrutiny for government jobs? Or does the dissent say rational basis review is fine, but the law does not pass rational basis review? What does the dissent say? Is it the level of review or the result of the review that the dissent finds wanting? What? Result. Okay. So yes, if you read, doesn't really try to say hiring aliens or excluding from hiring aliens. Well, excluding aliens from hiring for government jobs should be subject to strict scrutiny. I think it's because of the Foley case, right? It'll be difficult to make an argument that, aliens can be part of the police force. But the dissent says, it is irrational. Because why? Yep.
That doesn't really make sense with the court's argument.
Yep. So if you look at page 163, all the way at the bottom, the state apparently under 3001, paragraph 3, would not hesitate to employ an alien teacher while he awaits to attain citizenship, even though he may fail to attain it. So there is that exception for those who have applied for citizenship. Even if you fail, as long as you have submitted the application, you can be hired. Then, the goal of having only citizens perform apparently this very important government function does not make sense, right? And the court gives other reasons. Okay, so this is how the court uses this level of scrutiny in deciding constitutional cases. Next week, we will look at, let's see.